testified that. He has seen it, and he has his own pictures of it. And they haven't, I would suggest if this court is going to seriously entertain any of this abusive discovery request, that the court put the burden on them to have Dr. Blake come out of hiding and testify that there's some deficiency in his photos. And we'll do it on a photo-by-photo basis. We have wasted valuable day. Well, I mean, I think the legal process calls for something like that, Your Honor. No. I know it's real easy to say, well, no, just give it to him, but I don't think the process calls for that, Your Honor.
No, what struck me, Mr. Harmon, is I can see myself having to start another one of these hearings and having to look at all these photos. And
well, but if the process calls for that, we may have to do that, Your Honor. I think it's real simple to just say give him new copies when I mean, we have shut down the state lab to satisfy Dr. Blake's schedule. You know, if you've ever done lab
Mr.
work...
Harmon, you're just misinterpreting the court's oy vey reaction.
No, I just wanted to make sure that I didn't misinterpret it, Your Honor.
Okay.
But, you know, they haven't shown that they've been deprived of anything, and the only way they can do that is to bring Blake out of hiding and put him up there.
Okay.
And they're not going to do that.
You know, very briefly, when their experts are called, they're going to have the pictures and we'll be entitled to review them. I'm just trying to save some time here because we may want to make blow-ups of their pictures, and if we don't get them until the witness testifies, it's going to cause a time delay.
All right. The issue, though, is access, knowledge, disclosure. You've had that. Request is denied. All right. Thank you, counsel. We're in recess. 1:30. Has your office given you any indication as to when we might be getting an update as to his condition and when he might be able to rejoin us?
No, I have no indication of that at this time, and I probably will not, even by the conclusion of today's proceedings.
What's the status of your position as far as proceeding in his absence?
After we address the court with respect to the discovery matters and the misconduct issues, I think we'll be in a better position to assess that.
All right.
Myself and Mr. Darden would like to address you on these matters, Your Honor. They are numerous, and the court has requested some very specific statements concerning what we desire with respect to each of the items, each of the witnesses, and each of the statements that were improperly made by counsel. I must share with the court that I feel very outraged at counsel's statements earlier this morning concerning his representations that were trying to prevent him from telling the truth, and that is such a falsehood. If Mr. Cochran were standing up and telling the jurors the truth and had not hidden his witnesses from us willfully in violation of this court's order, we would not be before the court today. An opening statement would have been concluded, and the witness would have been on the witness stand. Unfortunately, because of the nature of this misconduct, which is egregious and flagrant, and not the minor violation that he attempts to represent to this court, he's attempting to sweep it under the rug, claim ignorance, and use Mr. Douglas as a sacrificial lamb, and that is absolutely inappropriate. That counsel should bear the brunt of his own misconduct, which was willful and deliberate and intentional, and is in effect a thumbing of his nose at this court's order. It is, yes, it's couched in nice smiles and ingratiating remarks, but that should not deceive the court, and I'm sure it doesn't. What lies behind it is a willful desire to flout the law. And it violates both the law, it violates us both legally and morally. Legally, it's a violation of 1054 in both spirit and letter of that law. Legally, it's a violation of this court's direct order to counsel, and morally, it's a violation of the jurors' right to the truth. They've been lied to, they've been deceived, they've gotten half-truths from counsel. He has deliberately shown them items that were taken out of context, given them half-truths, giving them actually pieces of statements that led to a diametrically opposed representation of what really was being stated. And counsel is telling the court, oh, that's no big deal. If I mislead them, then the people can come back in closing argument and redress all the wrong. Counsel knows very well that we cannot, because our closing arguments are months down the line, and well, he knows it. Counsel has very carefully and very cynically weighed the risks and the benefits of his misconduct, and he has rightfully assured himself that the risks, if any at all, are far outweighed by the benefit. These jurors have now heard statements and representations of counsel about witnesses that the people were never informed of, that the people could have addressed in their opening statement, and even could have called in their case in chief in order to show the jurors the kind of witnesses that will come forward in a case like this for the sole purpose of gaining celebrity. And Mr. Cochran willfully withheld their names, knowing that what he was going to do was cloak them with a false aura of credibility before this jury and sandbag the people so that we were unaware of them and unable to address them in our opening statement. He made statements concerning witnesses that might never appear because of fear, thereby cloaking a witness with credibility who would never appear probably because of fear of exposure, because they are not telling the truth. Instead, now he's created ideas and notions in the minds of these jurors that there are people out there that will not come forward that would be holding the truth, except for the fear of harassment. And that is not true. There's no evidence of that whatsoever. In fact, we have witnesses coming out of the woodwork who know nothing about the case, claiming to know something just so they can get involved. So counsel has committed numerous acts of misconduct. And for him to turn to us and say we're trying to get into his mind and we're trying to prevent the truth from coming out is outrageous, is disgusting, and is appalling to me as an officer of the court. He knows that is not the case. And to allow that kind of statement to be made, and in essence that is the statement that he made to this jury, is worse than appalling. It is no longer just a fear, Your Honor, that the people's right to a fair trial is going to be damaged. It is a reality. It has been damaged. It's not damaged beyond repair, because if certain admonitions are made, certain sanctions are undertaken, and we were able to present the witnesses, the truth will come out, because our case is strong. And I'm not worried about our case. What I am worried about is the way these jurors are being manipulated so cynically. They're being told, for example, why didn't the people tell you about this witness? Why didn't the people tell you about that witness? There's a real simple answer for that. They hid those witnesses. How are we supposed to tell the jury about witnesses they never told us about? Witnesses that the court ordered them time and time again to divulge. And willfully they told this court they had no such witnesses. 7 months old these statements are. 7 months old these names are. And only on the very day of his statement to the jury do we find them out, and at the close of the day, no less. Mr. Darden will address that further. I'm going to address the court solely on one aspect at this point, and that is that we are going to ask the court, at first blush, before opening statements are resumed, to admonish the jury, to tell the jury that they are to disregard the statements made by Mr. Cochran concerning the witnesses that were improperly withheld from the prosecution. And to admonish the jury, in effect, that the withholding of that information was misconduct, was in violation of a court order, and in violation of the law that requires both sides to exchange their witnesses and their statements. The other problem is that, Your Honor, I know the defense is arguing, well, we gave them the names of the witnesses. Yes, they gave us no address, they gave us no phone number, and they gave us no statement. Having a blank name on a list of 200 gives us no clue as to what that person might say and whether or not they should be high priority in terms of our investigation. They stand before this court repeatedly saying ridiculous things like, oh, there's 900 lawyers in the DA's office. Yeah, there's also 80,000 cases in the DA's office. Believe it or not, they're not all working on Simpson, nor can they. And there may be 9,000 officers, but guess what? They're not all working on the Simpson investigation either. They can't. Everybody is way overloaded. We have to prioritize. And for them to give us a name with no address, no phone number, and no statement on a list of 200 that contains a lot of bunk that we know they're not going to call is disingenuous and a fraud upon this court. We could not possibly have investigated these people, and to give us these late statements is outrageous misconduct. So we ask that the jury be informed of that fact, that counsel's remarks that relate to the mentioning of those witnesses, either by name or by content of their statement, that they are ordered to disregard them because they were mentioned in derogation of a court order, We are also asking that the court admonish the jury concerning the representations of counsel about witnesses that may not appear due to fear, that there is no such evidence whatsoever. Such remarks made by counsel were improper, and they are stricken from the record, and the jury should be ordered to disregard them. Furthermore, the people will be requesting some additional time to conduct investigation on the numerous witnesses that we have just been given at the close of opening statement day yesterday, as well as the day before. And should the court grant us the continuance in whatever amount of time that it does, we would ask that the court inform the jury as to the reason for the necessity of that continuance, that it was necessitated by counsel's misconduct in failing to turn over the information that it was ordered to turn over by the court. Mr. Darden will address the court on the remaining requests we have pertaining specifically to each witness and to our request to reopen the opening statement.
Mr. Darden.
You want me to do it?
Good afternoon, sir.
Your Honor, good afternoon. Many of the witnesses disclosed to us by the defense the past 2 days are witnesses whose statements had not been given to us on any prior occasion. And the first is Mary Ann Gersh. And as the court will recall, Mr. Cochran told the jury that Mary Ann Gersh saw 4 men running from the scene of the killings on the night of June 12. We have never been given any discovery relative to that witness, that is, until yesterday. And that was given to us after Mr. Cochran already made comments regarding this witness before the jury. Now, this is obviously a material witness, one would think. That is, if one could believe her testimony. Mr. Douglas had this statement in his possession. The defense has had the statement in their possession for several months. Since July. They could have given it to us back in July. They could have given it to us back in December when they were squawking about our discovery problems and while they were asking the court to sanction us. But they didn't do that. They didn't do that throughout that 5-month period in 1994. And in December, when the court began to attempt to set a date for opening statements in this case, the defense didn't turn over this statement. And when they learned the exact day that opening statements would begin, they didn't turn it over. And when Mr. Cochran's opening statement was delayed a day, they didn't turn it over. And when they came into court to begin Mr. Cochran's statement, prior to that statement, that morning, they didn't turn it over. And there's only a few reasons that they didn't. First, they knew that had they turned over this statement this late in the game, the court would have precluded them from utilizing the statement in opening statement. The court would have sanctioned them, as they did us. And they were also aware that had the prosecution known about this particular witness, we would have discredited her. We have only known of this witness 24 hours, and already we know she has 9 lawsuits pending. In the DA's office, in our bad check section, there are $10,000 approximately in bad checks that relate to this person. She has defrauded the J.W. Marriott Corporation of $23,000 by staying in their hotel and not paying for it. And there's much more, much more regarding this witness, but we need time to investigate this witness, Your Honor.
What's your reasonable estimate as how long you need to investigate into the background of Ms. Gerchis, since People versus Jackson at 15 Calap 4th, 1197 at page 1203 indicates what the remedy is: having a meaningful opportunity to rebut or impeach. So what are we speaking of in terms of investigation to adequately be prepared to rebut and or impeach that testimony or that proffered testimony? That's the issue.
Your Honor, we are concerned that perhaps this witness is not the person she claims to be. She is not the person she is not the real Marianne Gershis. There is a hint that perhaps she is not that person, and we're concerned about that. And she is such a critical witness, apparently, to the defense, that I believe it would take approximately 30 days to carefully search out the background of this individual.
All right, do you have any other comment as to this witness?
Well, in addition to the sanctions mentioned by Ms. Clark a moment ago, and in addition to a 30-day continuance to carefully investigate this witness's background, I would ask that the court strike any reference to this witness from Mr. Cochran's opening statement and advise the jury that the court is doing so because of Mr. Cochran's willful and flagrant violation of the rules of discovery. In addition, I think that the prejudice that the people have suffered as a result of this flagrant violation, this willful violation, this egregious conduct, that the prejudice is so extreme, I believe that the people should have an opportunity to reopen their opening statement.
Do you have any authority for that proposition?
There is no case law directly on point, Your Honor. However, the court does have discretion in terms of the order of proof. And under 1054.5b, the court has the discretion and the right to order any lawful remedy or legal remedy available to rectify the harm caused us by the defense in this case.
But
To reopen would be only fair.
how does that dovetail to 1093, setting the order of trial in the ordinary criminal matter? Do I have the discretion under 1093 to alter that to allow you to reopen?
I believe so, Your Honor. 1093 says that the proceedings shall proceed in the following order unless otherwise directed by the court. I ask that the court allow us a second opportunity. There is no law against it. It is not our fault that we're in this position. Back in December, you ordered us to provide the defense with discovery. You literally forced us to work 48 hours straight almost to comply with that discovery order. You told us to have discovery to the defense by 5 o'clock on a Friday afternoon, and we worked and we complied. Had we come into court and did what they did and tried to pull something like this, our conduct back in December, which as I recall the court agreed was nothing more than negligent, wasn't nearly as egregious as what has happened in this case. And in response to our mistake, an honest mistake at that, the court gutted the domestic violence evidence in terms of how it could be presented in the case. The court precluded us from calling witnesses in the order we wanted it to call those witnesses, so that now the defense has a hand so deep in our pocket at this point that they're literally dictating the order in which the witnesses will be called by the prosecution. Such sanctions ought to flow both ways, Your Honor.
Well, that's why it's called reciprocal discovery.
That's why it's called reciprocal discovery, and that's why it's a two-way street, and the water should flow both ways and in both directions. We had to do it. I'd like to put my hand in Mr. Cochran's pocket at this point. It's only fair. He created this situation. He didn't have to allow this to happen. The next witness is Dr. Carrie Mullis, an apparent DNA expert on PCR. Prior to the opening statement, we received no statement or report regarding this witness. I have not had a lot of time to search all the documents given the event of yesterday evening.
Was Dr. Mullis on any of the witnesses lists for the Kelly hearing?
Well, one of the things we did with regard to the DNA hearing in the witness list is this. After they allegedly waived their Kelly trial, we updated our witness list to include the people we intended to call on the DNA issue. This doctor is not on any non-Kelly Fry witness list. And even so, we've never received any report or any statement relative to what this doctor would testify to. We require time to investigate this witness's background. I don't know much about him, but I understand that he is a very controversial figure in the scientific community. We need time to gather transcripts of his prior testimony. We need time to review the scientific literature, to review his background and his training. As the court is aware, that can be very difficult to do. Not anyone, and not just everyone, can perform a task like this as it relates to a scientist such as Dr. Mullis, and it's going to take time. It's going to take about 30 days. We would ask that the court, in addition to the admonition, instruct the jury to disregard any mention of this witness. We would ask the court to allow us to reopen our opening statement. And as to Dr. Ron Fishman, Your Honor, we are somewhat acquainted with Dr. Fishman. In fact, I met Dr. Fishman, but unfortunately, I didn't have a subpoena on me when I met him. I did, however, cause a subpoena to be issued for Dr. Fishman's appearance in this case. We have been attempting to serve Dr. Fishman and to speak with Dr. Fishman since December 14. We believe that if Dr. Fishman were honest and called to testify and testified honestly, we believe that he would testify that as Nicole Brown left the recital on June 12, he overheard this defendant say, "I'm going to get her. I'm going to teach her a lesson," and words along those lines. And so we have telephoned him, and we have gone to visit him, and we have attempted to serve him. And on January 19, 1995, our investigators were outside Dr. Fishman's home. They met. They told him they were there to serve him with a subpoena. And he turned and he ran. And he ran back inside his house and he locked the door and he wouldn't come out. And the investigators placed a subpoena in the mailbox and shouted through the window, "Dr. Fishman, consider yourself served." But Dr. Fishman should have been here yesterday, or he should have called the prosecution to be placed on call, and he has done neither. The defense has a statement from Dr. Fishman. We don't have it. We should get it. We should be allowed time to investigate Dr. Fishman. And there are other problems with Dr. Fishman. When the defendant was arrested on June 17, there was a prescription of Xanax, a depressant, in his black bag. The medication apparently was prescribed to Dr. Fishman's mother. I don't know why it's in the defendant's bag, but it's issues like that and the issue of the recital that has to be reviewed and investigated. It's going to take time to deal with the issue of Dr. Ron Fishman, and I would ask for the same sanctions be imposed as it relates to Dr. Fishman, as we requested with regard to Mullis, Gershis, and the other witnesses. Dr. Lenora Walker is a different issue. The defense served us with her CV on January 24, but they have not provided us with any statements or any reports, as they are required to do under the law.
You heard Mr. Cochran's explanation that she had just been retained, was in the process of interviewing the defendant, preparing a report, so I assume it's not there yet.
Okay. Nevertheless, Mr. Cochran represented to the jury that Dr. Walker was going to form a certain conclusion and testify to that conclusion. So apparently Mr. Cochran is aware of what Ms. Walker is going to say, or Dr. Walker, I'm sorry, so what Dr. Walker is going to testify to. But Mr. Cochran also indicated that Dr. Walker had interviewed the defendant, and that she had conducted psychological tests? Well, that's discoverable. It's discoverable under Woods versus Superior Court at 25 Calap 4th, 178. That stuff exists. If Mr. Cochran knows enough about Dr. Walker to tell the jury what she's going to testify to, and if testing results exist, if actual tests exist, if there are interviews with the defendant, we have a right to all of that. And that's clear, I believe, in the law. In addition, Mr. Cochran has placed the defendant's mental state, psychological state at issue in this trial and before this jury. And I believe that we have a right to have access to this defendant for psychological testing. And that's an issue we'll take up again in a couple of days. At any event, it will take time to prepare for Dr. Walker. And the court might also recall that when Mr. Cochran was arguing to the jury, that he mentioned that Dr. Walker was watching us on television. So I assume Dr. Walker has some notes, and apparently she communicated her opinions and conclusions to Mr. Cochran, which Mr. Cochran communicated to the jury. We like to have that. We have a right to that. We make the same request. Regard to sanctions, strike it. Tell the jury to ignore it. Tell the jury that Mr. Cochran and the rest of the DREAM team have violated some very, very basic and fundamental discovery rules. The next witness is Michelle Abderrahman. She was Mr. Simpson's maid, apparently, and according to Mr. Cochran, Nicole once slapped her, Nicole Brown. And I've heard of this incident, and I believe that I've seen reports, some report as it relates to this incident. I know I've read it in the tabloids. And so we are somewhat aware of that witness. But our concern here is that perhaps Mr. Cochran has additional information, additional statements. This is his witness. We have a right to her statement. We have a right to discovery as it relates to this witness. And if the court would order the defense to turn over that statement to us immediately. And I don't believe we have it at this point. Do we?
I think yesterday you were given a statement from June of '94 from this witness. That's on the record at page 11/9/21.
Okay. It's our recollection that is merely a copy or is it a copy of a statement the police took? But our concern is this: if the defense has more information, an additional statement, additional notes as they relate to this witness, we would like to have them. And if they don't have them, we'd like them to stand before the court and represent to the court that they don't have them and that they know that they don't have them. If they interview this witness, subsequent to our interview of the witness, we want the notes. Okay? And if they interview the witness, subsequent to our witness, and if they fail to take notes, we would like the court to order them to reduce the conversation to writing. They have no right to take oral statements, decline to commit them to writing, and then hide them from the prosecution. Whether any additional sanctions should be imposed here, I think, depends on the content of any subsequent statement this witness may have provided the defense. Then there's Joe Stellini. This witness apparently was at the Tryst restaurant. He is a defense witness. We received no statement, no report, no notice, no information regarding Mr. Stellini from the defense prior to the opening statement. We'd make the same request that the court order the jury to disregard any reference to Mr. Cellini or any reference to anything Mr. Stellini might testify to. He should not be allowed to testify in this case until such time that the witnesses who were included on the defense witness list and whose statement was provided in a timely manner and in a lawful manner, until those people, those witnesses are exhausted. Same sanction you imposed on us, Your Honor. That should apply to him, Mr. Cellini, and it should apply to the rest of them.
You're asking that the court order that any testimony by Mr. Stellini be delayed until the other witnesses on the previous August and December witness lists have been called?
Yes, Your Honor. And I think that should apply to each of the witnesses we were ambushed by yesterday and the day before. Then there's Dr. Batten. We are aware of Dr. Batten. We're aware that he was present on June 17th. He appeared before the grand jury. We asked him what happened in Mr. Kardashian's house just before the defendant fled. He told us that the defendant fled as soon as he heard that the police were on their way to arrest him. But we didn't ask Dr. Batten about any testing or the results of any test. We did not ask him about his expert opinion regarding blood or pathology. It was made clear to us that such topics were off limits, that he was a defense expert, and that to inquire in those areas would be to violate the attorney-client privilege, and we honored that. Mr. Cochran has told us that Dr. Batten will testify that the perpetrator should have been drenched in blood. It would seem to us that Dr. Batten has reviewed certain items and objects. He has perhaps conducted some tests. He has rendered an opinion. We would like those reports. We would like that opinion. And there has to be one, because as I understand the rules in the opening statement, counsel is not allowed to inform the jury of evidence or information that they do not in good faith and reasonably believe will be heard from the witness stand or in open court or received as evidence. If Mr. Cochran or the rest of the dream team have had oral conversations with Dr. Batten regarding his conclusions and opinions, then I would ask the court to order them to reduce these conversations to writing, and that they do it now, immediately. We would ask that the court impose the same sanctions, the sanctions we mentioned earlier. Strike it from the record. Tell the jury to disregard it and ignore it. Tell the jury that the defense, the dream team, America's finest defense attorneys, tell the jury that these lawyers have committed misconduct. They have deceived the court. And that they have violated the basic and fundamental rules of discovery, and that they have impinged upon the people's right to a fair trial. Next is Christian Reichart. He is Faye Resnick's ex-fiancée. She dumped him and he's out to get her. That's fine. I have interviewed Mr. Reichart myself with the use of a court stenographer in the presence of his attorney, Mr. Dominique Rubakava, and we have turned that over to the defense. If there is an additional statement or additional information, we would like to have it. If there were additional conversations not reduced to writing, we would ask that the court order the defense to reduce those conversations to writing. If the defense intends only to rely on the interviews conducted by the prosecution and by the LAPD, then that's fine, but they should stand before the court and inform the court of that. If that's what they're going to do, then there's no surprise necessarily as to Mr. Reichart. But I will say this, and that is that no statement has ever been received from the defense as it relates to Mr. Reichart. In addition, Mr. Reichart is not on the defense witness list. So maybe I jumped the gun on this one. Should strike it. And he should move to the back of the line. And we should be allowed to do as the defense has been allowed to do to us in this case. We should be allowed to let them know when they can call this witness. There's Dr. Barbara Wolf and Dr. Gerdes.
Take them one at a time.
And Dr. Lee, and we can say the same thing about each of these experts, and that is that we have no reports or statements from these witnesses.
All right, Dr. Wolf, Dr. Gerdes, and
Dr. Lee.
Lee. All right.
I think I've already indicated that we have nothing from Dr. Baden.
I thought you had one report from Dr. Lee already.
Yes, only as it pertains to the envelope.
Well, that's one.
Well, we heard yesterday that he was the foremost crime scene expert, the best in the world, and he was going to testify about the crime scene. Where's the report? Where's the opinion? We require immediate disclosure of these expert witness reports. We'd ask that the sanctions already mentioned, requested by us as they relate to other witnesses, apply to these witnesses as well. And then there's the envelope, Your Honor. The envelope that Mr. Cochran waved in front of the jury yesterday. The envelope which contains an unspecified knife, as I understand it. I'm not sure exactly what's inside the envelope. I have seen the report. I have not seen the item, but the defense has seen the item. We have no knowledge or information as to where the item came from, how it was recovered, who handled it, when and where, how it got there. We know nothing about this item, except what we know from Dr. Lee's report. But the defense knows everything about it, and they apparently intend to introduce it as evidence in this trial. If that is the case, Your Honor, we have a right to know the true circumstances surrounding this particular object. We have a right to know how it was recovered, how the court was contacted. We have a right, I believe, to know all the details surrounding this particular item. And we require immediate discovery as it relates to this item. And I would suggest to the court that the display of that object yesterday was just one of many flagrant violations of this court's rules and orders. This court ordered us to give each side the opportunity to view any exhibits that might be introduced before this jury during opening statement. We didn't get that opportunity. Mr. Cochran just pulled it out, waved it in front of the jury.
That was not exhibited to you during our two show and tell sessions.
I've never seen it before, Your Honor.
Thank you.
And I had no knowledge that it was about to be presented to the jury. By the time I saw it, it was in full view of everyone in the room, as I recall. The jury should be ordered to disregard any viewing of that item. They should be ordered not to speculate as to the content of that item or the weight to be attached to it. The jury should be informed that this was a low blow and a cheap shot. That it is gross misconduct. A serious violation of the court's directives and orders. Mr. Cochran mentioned yesterday that certain witnesses would testify about the defendant playing cards on June 12, and that he suffered some acute attack of arthritis, I believe, some form of arthritis. Well, it is apparent that Mr. Cochran intends to call these witnesses to testify. Well, who are these witnesses? Where are their statements? Where do they live? We don't even have the names. We'd like that information. We require immediate discovery. And the jury should be advised that the defense is up to cheap tricks, and that they're in violation of the court's rules, and that the display, or rather the mention of this card game, the mention of these witnesses, is a flagrant violation of the court's order. The defense also referred to 2 doctors who they say examined the defendant. Who? Where are the reports? Where are the statements? Where are the test results? We didn't get any of that. We didn't get notice.
You have the cite to the record where that is
Yes.
in the transcript. I'm just wondering if you had it. All right, move on, Mr. Darden.
As it relates to those 2 doctors, Your Honor, until we know who they are, how they specialize, or what areas they specialize in, until we get the discovery, it's difficult to seek a particular sanction. But I'll say this, I cannot imagine, I cannot understand why anyone in a case like this, especially given the supposed quality and abilities of these defense lawyers, why anyone would want to hide expert witnesses in a case like this. It's just unfair. It's mind-boggling. Howard Weitzman and Skip Taft were mentioned yesterday. If there's been a conversation with Mr. Weitzman and Mr. Taft, we would like that statement. We would like that conversation reduced to writing. We would like discovery. Any mention of these 2 gentlemen should be stricken. The jury should be admonished. They should be advised to disregard counsel's comments regarding these 2 witnesses. Next.
How do you suggest I deal with the attorney-client issue that's obviously going to be raised in response?
I don't know whether there is an attorney-client privilege issue in this situation. I don't know what they have to say. We know they have something to say, and whatever Mr. Cochran has said so far certainly ought to operate as some form of waiver as to some or all of any conversations.
Just a few legal issues here.
Just a few.
Go ahead.
Mr. Cochran referred yesterday to an unspecified doctor who would testify that the defendant's cut, one of the cuts, maybe both, on his left hand is consistent with a knife cut.
I think he said inconsistent.
Okay, inconsistent. I'm sorry. Thank you, gentlemen. Well, we'd like to know who that person is. We'd like to see his report. We'd like to know what qualifications he has to form such an opinion. That should be stricken from the record as well. That's an expert witness. Counsel knew that this person would be testifying. You know, as I sat there yesterday, the day before watching Mr. Cochran, I noticed that his opening statement, most of it was typed. He had time to type it, to type out that opening statement, and it was a very fine opening statement, and I'm always proud of Mr. Cochran whenever I see him in court, Your Honor. I love him, I just don't like to go up against him. But if he had time to type his opening statement, then he had time to turn it over. And I'm disappointed in Mr. Cochran. I'm disappointed that he hasn't turned over that information to us, because just this past weekend, Mr. Cochran and I had a telephone conversation on Sunday evening, and we discussed discovery issues. I discussed with him issues and information which he could not otherwise learn or obtain until the following Monday or Tuesday. And I advised him of these things so that he would know that they were in existence and so that he wouldn't be surprised. And so I'm surprised to stand here today before the court, Your Honor, and I'm disappointed in Mr. Cochran. I would think that he would return to me the same professional courtesy. And the court will recall that we have been ordered to turn over to the defense, literally within 24 hours or one business day, the name of any potential witness, as well as the statement, as well as the tape of that statement, as well as a transcript, if a transcript exists. These are the rules that the court has set for the prosecution in this case. But no rules have been set apparently for the defense, or if rules have been established for the defense for some reason, and I think I know what that reason is, they don't feel as if they have to live up to those rules or to follow those rules. Apparently they feel that they're above the rules. This conduct is outrageous. Mr. Cochran next described an unspecified gentleman would testify to having had an affair with Nicole Brown. I don't know who that individual is. I'm confident that it won't be Mr. Marcus Allen, because I traveled to Kansas City and I was present with 3 police detectives when Mr. Allen told us he never had an affair with with Nicole Brown. And so if it is Mr. Marcus Allen, or if it is some other person, we would like the discovery, Your Honor. We'd like to know the identity of that person. Mind you, that we don't think it's going to prove to be relevant in this case anyway, but in the event that it does, counsel has dragged this information in front of the jury in an attempt to sully the reputation of the deceased victim, and that's fine. That happens in court. But we have a right to that information, to the name of that individual, and to that statement, that individual statement. And if they think that they can just sit there and talk to these people on the telephone or in person and not reduce their conversations to notes, or if they think they can reduce their interviews to notes and then not turn them over, well, that's not the law. That's not the law in this state. Now, you can't sandbag the opposition that way. And I understand Mr. Cochran when he stands here and tells us how he's the only one interested in the truth in this case. And I appreciate that. But I would suggest to the court that this conduct, as it relates to the discovery in this case, is completely inconsistent with any desire to determine the truth or to have the jury determine the truth. And I would like the jury to learn the truth regarding the murders of these two people, Your Honor. Win or lose, as long as the truth comes out. But the type of conduct exhibited by the defense these past couple of days and over the past several months, I mean, they had the audacity to stand here and demand that you sanction us, all the while knowing that they had statements from material witnesses that they took 4, 5, and 6 months prior. And they knew they had them, and they knew they hadn't turned them over. And they stood here and asked you to sanction us. The gall. The court should impress upon the defense that the rules apply to them. It doesn't just apply to the poor civil servant lawyers over here on the other side. It applies to the dream team, too, and to the dream defendant. It isn't fair. What they've done in this courtroom the past couple of days is not fair. I have never, ever seen anything like this. Mr. Cochran next made reference to tire tracks and another trail of footprints.
Take those one at a time.
Okay. It is apparent to us, based on his comments yesterday, that they have an expert. And maybe that expert is Dr. Lee, or maybe it's some other person who has reviewed this issue on behalf of the defense. Whoever that person is, Mr. Cochran has indicated that they will probably be testifying in this trial, or that they will be. We have a right to know who they are. We have a right to any statements they've made, any tests that they've conducted, any conclusions that they've drawn. We have that right. And it's just this isn't just some right that just came to us the Monday or on January 1, 1995. This is a right we've had for years and years and years. And Mr. Douglas and Mr. Ullman and Mr. Cochran have stood before the court and told the court that we understand. This is what they said. We understand our responsibilities under the rules and laws of discovery. And yet they've chosen to ignore those rules and those laws and the court's order. If they have experts or reports or studies or anything not given to them by us, any photographs, anything relied upon by the expert they intend to call, we have a right to have that. And this expert, if there is such an expert, should not be allowed to testify in these proceedings until the end, Your Honor. Until the end, and the jury should be admonished, instructed to disregard Mr. Cochran's comments regarding this witness in his opening statement.
So you have the same comment as far as the tire tracks and the footprints.
Yes, Your Honor. Next, Mr. Cochran mentioned Dino. And I apologize if I mispronounced the last name. It's Buccola, B-U-C-C-O-L-A. And this relates to his observations at the Red Onion, an incident which was described in our domestic violence motion.
Is this one of the individuals in the car?
Yes. We received a statement, I believe yesterday, regarding this gentleman.
That was not one of the statements
Was it?
yesterday. It's not on my list of items turned over. Mr. Douglas?
Okay. Yes, as they were running to the elevator, here, have some more discovery. They gave us 2 reports just that way yesterday.
That's not correct, Your Honor.
Well,
Wait your turn, Mr. Douglas.
we'll get there. Mr. Darden, all right, what is the date on this witness statement?
Do you have it here? I believe it is, well, why don't the court inquire Mr. Douglas, if you don't mind? I don't have it immediately available.
Okay. But you have now a statement from Mr. Bucola
Yes,
regarding that incident.
yes.
All right.
I believe it's dated, you would inquire?
No, I'll find out soon enough.
Okay, well, it's about January 25 or something like that.
Okay.
And it raises a significant issue, I think. As we proceeded with our investigation, we interviewed witnesses on January 1, and January 2, and January 3, and dates like that, and January 10. And as we turned those witnesses over to the defense within 1 business day, and in compliance with the court's order, we were nevertheless precluded from mentioning those witnesses in opening statement. We were precluded from calling those witnesses until the end of the prosecution's case. And it was no fault of ours that we discovered these witnesses on January 1 and turned them over the next day. It was no fault of ours. And still, we had to suffer some form of sanction. We suffered a sanction for being diligent. They've given us this gentleman's statement taken just a few days ago. He should move to the back, just like ours.
Now, I don't recall this person being mentioned in opening statement or any issue.
Okay, then he should just be required to move to the back there. And Mr. Cochran should be precluded from mentioning him in the event he intends to.
Certainly. Madam Reporter, how are you doing? All right, I'm going to go another 15.
We received a number of statements on January 25, Your Honor. Mr. Bacola's statement was one. We received a statement regarding Mr. Jason Wood, and we will seek no sanction as it relates to Jason Wood. We interviewed him, we're acquainted with him, and the report we received was consistent with what we already know. And so we will seek no sanction, but we will ask the court, however, to ask the defense, do they have information in addition?
Certainly. Thank you.
Next, Your Honor, there's Ronald Taylor. We received his statement on January 25th. He was on their August 31 witness list. However, they waited until January 25th to give us a statement. There was Paul Solenshine, Solenshine.
Hold on. Hold on. All right, Paul Sunshine, the Rubens employee.
record, we did receive an earlier statement on Taylor. Don't talk to me, okay? We did not receive a statement on Paul Solenshine until January 25. As I indicated, he was on the August 31 witness list. However, no statement was provided. The same applies to Rosita Ruban, Rheuban. We require time to investigate the content of their statements and determine if they have information relevant to these proceedings. They should not be allowed to call these witnesses.
Are the people intending on presenting any of the items seized from Mr. Cowling's automobile?
We have not yet made that decision, Your Honor. They should be precluded from calling Mr. Solenshine and Ms. Ruban until the conclusion of their case and until we have been given a reasonable opportunity to investigate their backgrounds and the content of any statement they might give. Next, there is the statement of Tony Parker given to us on January 25. We had no prior discovery regarding this witness. We require additional time to investigate the content of his statement as well as his background. We were given a statement, or rather Kevin Whalen's statement, and he claimed to have gotten the defendant's autograph on June 12, 1994 at 11:20. You would think that he might be a material witness to the defense, and I'm sure they saw it that way. And he was on their August 31 witness list, but they didn't turn that statement over to us until January 25th, 6 months after the homicides. Yesterday, Mr. Cochran mentioned, strike that. On the January 25, we received a statement from Narendran Singh regarding the possibility of a tape of some kind at the Mezzaluna restaurant. This person was on the August 31 witness list. We received that person's statement on January 25, 1995. And next is Alex Castillo. He has some information regarding a beeper, a pager, and he was on the defense August 31 witness list. But it was not until January 25, 1995 that we received a statement or a report. I have one moment, John.
Certainly.
Time and time again, the prosecution stood before the court advised the court that the defense was playing fast and loose with the discovery rules, with the evidence. Each time, a member of the Dream Team stepped to the podium and advised the court to what they thought the law required. They advised the court that they had no discovery, or they had no reports, or they didn't intend to call a witness, or that they had no duty to turn over relevant and material information, statements from material witnesses that they knew from day one they would want to call in this trial. And they did that time and time again. Mr. Douglas did it just last week on January 20. The court may recall, and this is at volume 73, at page 11319, where Mr. Douglas informed the court, certainly, Your Honor, the court understands our obligations under the Discovery Act, and certainly, Your Honor, with this fine collection of lawyers, we understand our obligations under the Discovery Act. And I think their understanding, Your Honor, was probably correct, and that is that they had a duty to turn over the statements of these material witnesses. And I think they understood that. I think the law is pretty clear there. I think Mr. Ullman stated it rather succinctly and clearly when he said, in circumstances like these where trial has already begun, each party has a duty to turn over to the other party discoverable material immediately. And Mr. Ullman said to the court, Your Honor, immediate means immediate. It means now. It means soon as possible. And that, as I recall, was the court's understanding of the term. Well, we've been in trial since September, as I understand it. Well, it is that section of the discovery rules that applies to these defendants, to this defendant and these defense attorneys. They should have turned over this information to us immediately. But they didn't. They wanted to sandbag us. Had they turned the information over to us last week or at Christmas or on December 14, as we did, the court will recall that on December 14, we turned over discovery to the defense, and you had to pull them off the ceiling. It's 6 weeks later now. The sanctions the court imposed on us back on December 23rd and earlier are still in effect. They've had 6 weeks to conduct an investigation, and in that 6 weeks, I don't know what they did in terms of an investigation, but in that 6 weeks, they certainly had an opportunity to think about the issue of discovery. I mean, they filed a 40-page brief on the subject. They argued it to the court day after day. They understand the law. They understand the rules. They know that they are not allowed to turn over discovery to us after Mr. Cochran has mentioned the content of that discovery before the jury already. They know that they have a duty to turn over information to us immediately. But they didn't do that. They didn't do it last year. They didn't do it last month. They didn't even do it the morning before Mr. Cochran began his opening statement. And that's outrageous. That's outrageous. And they didn't do it because they knew that had they done it, you would not have allowed Mr. Cochran to poison the minds of these jurors with hearsay on top of hearsay, with the content of statements given him by witnesses who are completely unreliable, and whose background I am sure that if Mr. Cochran knew or was aware, he would not have even mentioned. When the voters in this state passed Proposition 115, there was a clear mandate, and that mandate was no more sandbagging, no more sleazy trial tactics, no more abuse of the process or of the system or of the courts. As the court already alluded to earlier, discovery became a two-way street. I don't know why the Dream Team can't seem to understand that or grasp that, or why they don't want to follow the rules. I understand that they have a celebrity client, and I understand this is allegedly the biggest murder case ever. But the rules don't stop just for this case. The rules apply to this case. Had we done what they did, I shudder to think what the court would have done to our case. Because even despite our innocent and negligent mistakes in terms of discovery, you've gutted our case to some extent. You've dismantled it in many respects.
Rearranged.
You rearranged it all right. And I don't think that's fair. But the bell has already been rung, Your Honor, and the shot has already been fired. And once the shot's fired, as Mr. DeBlanc stated last night on television, once the bullet's out the gun, you can't get it back.
You had time to watch television last night?
I heard about it. I heard about it, Your Honor. I've missed the entire NBA season up to this point, and I am upset about that. But the people have a right to a fair trial just like Mr. Simpson does. And we have a right to play on a level field. And that field is supposed to be level and supposed to be balanced. Well, there is a terrible imbalance now. And this imbalance is brought about by the Dream Team's refusal. There's intentional and willful disregard some very basic and fundamental rules of discovery. This is their fault that the field is no longer a level playing field. It's their fault that things are out of balance. And I want the court to understand that it's not, so much of Mr. Cochran's opening statement the other day. I mean, he did what I figured he would do. He's a good lawyer. They say he's the best. He's a friend of mine. I'm proud to have him as a friend of mine, but I'm disappointed in him. But I want Mr. Cochran to know, Mr. Simpson too, to know that we're not just here playing games either. We may just be civil servants and blue-collar lawyers, Your Honor, but we intend to win this case. But the only way we're going to win, and the only way we can fully and fairly participate in this process, would be if the court rectified this imbalance. And I believe the court must, because this problem and this issue, it's more than just an affront to the prosecution. It is an attack on the integrity of this court. They violated your rules, not just mine, not just the legislature's, not just the rules of court, but your rules, Your Honor.
The legislature had nothing to do with this, Mr. Dard. Do you know that?
Thanks for pointing that out to me, Your Honor. We would ask that the court admonish the jury, and we would ask as well that we be granted a brief continuance so that we can fully assess what has happened, so that we can investigate the backgrounds and the information provided to us in court these past couple of days. And we think we have a right to that. I think we have an absolute right to that. The code section speaks to the remedies the court can provide in a situation like this, where there exists such a flagrant violation of the code. And we would ask that the court allow us to reopen our opening statement. And to correct the imbalance, to make the playing field level again. I'm sure Mr. Simpson didn't play on lopsided playing fields back when he was in the NFL, I mean, there were 11 guys on each side. It was fair. Of course, they had Mr. Simpson on their team. I just want a fair shot. We just want a fair trial. This ain't all about just winning and losing. It's about fairness. It's about justice. Starting to sound like Cochran, aren't I? Although there is little case law, no case law on the issue of reopening an opening statement, there is case law addressing the issue of reopening closing arguments.
I'm familiar with those cases. I was looking for one that dealt with opening statements.
So was I, and I was looking for that case until 2:15 this morning, Your Honor.
I know all about reopening argument, counsel.
And I would say this as
Let me
well.
rephrase that.
Okay.
I know something about it.
And I know the court knows that the court has discretion in terms of the order of proof, in terms of the order of the processes here in this case. And I would say something else, Your Honor, about what has happened here. We have something in the state of California called the Rules of Professional Conduct. It's ethics. And I'm not here to accuse my distinguished colleagues of being unethical. But I would like to point out, if I may, to the court, that there exists in the State Bar Rules of Professional Conduct, Section 5220, entitled Suppression of Evidence. And that section indicates that a member of the bar shall not suppress evidence, that the member or the member's client has a legal obligation to reveal or to produce. And there's also section 5-200, subsection B, which states that members of the bar shall not seek to mislead the judge or the trier of fact. What has happened here over these past months has been misleading. We've been misled. I believe the court has been misled. There's a clear indication that they have suppressed evidence, information that they should have turned over to the prosecution. And I'm not saying, hey, you should call the state bar or something like that. I'm not saying that. These are my friends. But I do think that they have committed a flagrant violation of the discovery rules, and they have caused the people to suffer extreme prejudice. How are you going to unring the bell? How are you going to get back the bullet once it's already fired? They brought this on themselves. We didn't do it to them. We'd like a fair trial, a fair shot at presenting to this jury the truth. We're not getting that. And we won't get it as long as they are allowed to play fast and loose with the rules. May I have one moment?
Mr. Dart, maybe this would be an appropriate time to take a court reporter recess. All right, we'll take 15. Mr. Darden, do you wish to conclude your comments?
Yes, Your Honor.
No, you had gone through
Yes. I have a
number of items.
Yes.
Do you have any other specific items? And I want to thank you for the specificity of your comments to the court.
Thank you, Your Honor. I just have a few brief comments, if I may. We would just like the court to know that we feel that we have a right, and we feel our position is supported by the law, but we feel that we have a right to preclude the testimony of some of the witnesses whose statements were given to us just recently, or whose statements haven't been given to us, but whose testimony was mentioned in front of this jury. And we're not asking for preclusion. And we're not asking for preclusion because we want to see the truth. We want the truth to come out in this trial. We could ask for contempt. We could ask the court to hold the defense in contempt, but we're not asking that. We're not asking that at all. We're not asking to report anybody to the bar. We're not doing any of that. All we're doing here today is asking the court to level the playing field. Now, just before I left out of here for the break, Mr. Bailey mentioned to me that perhaps what I really want is a mistrial. I don't want a mistrial. I like the 12 jurors we have. I like our case. I like our chances. We don't want a mistrial, Your Honor. We want to see the truth. We'd like to see these proceedings continue. And my distinguished colleague, Mr. Bailey, also asked me before we broke if I felt the need to run away. And I want Mr. Bailey to understand that I'm not going anywhere. We're not going anywhere. We're in search of the truth, and we're going to find it. We have found it. We want the jury to find it. We're going to stay right here, Mr. Bailey. We're going to finish this trial. We just need a little time to repair some of the harm caused by the misconduct of your colleagues and yourself. We just want a fair shot at it, John. Nothing more.
All right, Mr. Darden, let me ask you this. One of the remedies that you're asking for is for the court to advise the jury that I am striking from the record Mr. Cochran's comments concerning certain witnesses with regards to certain issues. Then you were also asking for the opportunity to reopen. Are those in the alternative or in the conjunctive?
In the conjunctive.
Because it doesn't seem to make sense if I'm going to strike it and then you come back and talk about it. Sort of defeating the purpose seems to me to be mildly illogical. they seem to be in conflict. Just an observation. Excuse me, Counsel, one glad, one,
We were both going to present on this because we just didn't have the time to.
Well, thank you, Ms. Clark. Just an observation. All right. Mr. Darden, have you concluded your comments?
Yes, I have. Thank you.
All right, then I have before me 27 specific items.
If the court may have more, I don't know if the court did a search of the transcript on its own, but that's all that we could pull out in the short time that we had.
Well,
I'm
I
sure
think 27 is plenty for today.
okay, we'll get another 27 for tomorrow, Your Honor.
All right, thank you. All right, Mr. Douglas, good afternoon, sir.
Good afternoon, Your Honor. Your Honor, I'd like to begin dealing with some of the discovery concerns raised, and Mr. Cochran would like to deal with some of the sanctioning issues that were raised. Your Honor, at the outset of this trial, the court reminded all counsel that the eyes and the ears of the world would be watching us today. It is my sincere hope, Your Honor, to bring dignity to the profession that I love. So I will not dignify the often vile, insidious, and long-winded comments by my colleague by responding in kind. Your Honor, I've known Christopher Darden for well over 10 years, and he has referred, in fact, to me and to my office, the parents of a young man who was once shot and killed while going home from school. So I cannot fathom that he would have entrusted that family in my care if he believed that I or my colleagues were as dishonest and as unethical as he has inferred. Your Honor, he comes to you seeking equity. He comes to you asking about basic fairness. As the court is aware, there's a concept in equity called clean hands. And that comment says that one cannot seek equity without doing equity in kind. And I submit to the court that before Mr. Darden comes and seeks equity, the true record should be considered so that the court can weigh and properly balance a response given the current state of the full record. Your Honor, in September of 1994, the prosecutors gave the defendants a list of 214 names. On January the 6th of 1995, the prosecutors gave the defendants 207 additional names. 5 more were added the following week. 3 more were added after that. 2 more were added since then. The first of his complaints were based on the thought that the defense had somehow dumped names without addresses or phone numbers on the prosecution, and how unfair that was to the prosecution. I give this court at this time the names of Art Shaftman, Behart Shaw, Joseph Peruli, Eliza Perez, Cindy Patterson, Brett Lobner, Mark Leon, Ray Kildruff, Bo Jackson, Carlos Hernandez, Richard Gonzalez, Don Detzler, Carol DePrima, Jay Swell, Victor Baffa, Nicholas Bolas, Donna Estes, Gary Kawakawa, Amanda Darling, Patricia Foy, David Prestholt, Cruz Priego, R. Wrench, Rodney Shelton, Norman Smith, John Stewart, Mark Stauffer, Jan Von Poppel, Philip Van Saun, Tony Waybright, Christine Wolford, and Charlotte Ward as just some examples of names given to the defense without addresses or phone numbers. That meant, Your Honor, that the defense had to try to find out who these people were, try to locate them, and try to identify them. They were names that were on the people's prosecution list.
All right, Mr. Douglas, if you will, at the conclusion of today's proceedings, give a copy of the list that you just read to the court reporter.
It has been done already, Your Honor. Thank you.
Your Honor, the court do this as well.
No, Mr. Darden, thank you. I'll hear counsel's argument.
Your Honor, the fact that they don't know who we are talking about when we may obliquely infer that there is a certain witness that might say certain things does not mean that we have committed misconduct. There is no case authority that they can cite, because there is no case to suggest that attorneys have an obligation to create discoverable notes or memos based on conversations with their client or based on conversations with retained experts. Your Honor, the district attorney's office has retained many experts to talk about DNA issues, to talk about blood issues, to talk about other issues. But among the 22,000 pages of documents that we've received in this case, there is not one handwritten note from Marcia Clark, from Christopher Darden, from William Hodgman,
Objection, Your Honor.
from Mr.
Counsel
Fairtlow.
He told us he was not interested in our handwritten notes. Specifically, that was an agreement he had with Mr. Hodgman. He is now misrepresenting to the
Ms.
court.
Clark, I'll hear your comments and rebuttal. Thank you. Mr. Douglas.
from Jonathan Fairtlow, from Scott Gordon, from Lydia Bodin, or from any other attorney, Sherry Lewis, Ms. Khan, or anyone else who has obviously had conversations with other experts. As well, Your Honor, there have been at least 12 DNA experts that have been noticed by both sides. Carrie Mullis, I strongly believe, was one of the names that were included in our list of experts that they are aware of. And I have not received one DNA report from any of these experts based on testimony that they intend to offer in this particular case. So we're talking about fairness, but we must also remember that both sides must have clean hands. The case, Your Honor, began back in June of this year. We have enlisted several attorneys who work out of different offices. At one time or another, we have used 6 different investigators that were involved in different pieces of investigation. They did not always work in concert. They did not always share their work product with each of the other investigators or with each of the other attorneys. One of the items that were turned over yesterday was a witness statement of Marianne Gertjes. That witness statement was obtained by an investigator with whom I personally have never spoke. That is an investigator who basically has done limited work on this case, and unbeknownst to me, one of the jobs that he performed was to interview and to obtain a statement of Marianne Gertjes. I represent as an officer of this court that the first day that I personally became aware of the existence of his statement, taken of Ms. Gertjes, was moments before I took the podium yesterday when Mr. Cochran gave me a copy, and I asked your clerk to make copies so that I could read myself. Certainly, Your Honor, I recognized fully yesterday that that was a violation to have not turned that statement over. But if the court were to read that statement, the court would see that Ms. Gertjes had contacted the district attorney's office and spoke to Patty Fairbanks in that office. That Ms. Fairbanks told Ms. Gertjes that I'm talking long distance to a psychic, so I'll have to call you back. That in her despair, Ms. Gertjes contacted the police department, giving them information that was brought before the jury yesterday. That Ms. Gertjes' name, address, and telephone number were included on the witness list that we provided in August of 1994. So certainly, Your Honor, while there may have been a problem with our physically turning over her statement, the surprise, the absolute shock and amazement that has been offered here is somewhat overblown. For example, Your Honor, not only did we give the name of Rosa Lopez, we gave her address as being a location directly next door to where Mr. Simpson lived. Not only did we give her name and her address, but we gave her statement as well. Despite having her name, her address, her telephone number, and a statement, there was no representative from either the district attorney's office or the Los Angeles Police Department to interview Rosa Lopez.
She's not one of the individuals under dispute here, Mr.
Your Honor, I'm
Douglas.
simply by analogy hoping to offer to the court that the protestations of prejudice are perhaps not in good faith, because though they had the very important information on Rosa Lopez, they never saw fit to go and interview her until Monday evening when Mr. Bailey stood up and explained to this court the significance of her testimony. I offer that to say, Your Honor, that yes, there may have been some facial violations of the code. However, before the court believes that there has been dire prejudice, you have to look at the equity. You have to look at the clean hands. And that's what I seek to offer to the court. Now, Your Honor, there has in fact been a list given yesterday because the court made it very clear on Monday that I would have to go through, on Tuesday. Monday, when I gave the name of supplemental witnesses, I told the court that these were the statements that were attached, and there were, I believe, several names and 6 statements that were attached. There was one name in particular, Scott Matsuda, that the people knew about and that they knew that there had been a statement of, and that statement was not immediately forthcoming because it was not attached in that packet. I then made a call, and the next day that name and that statement was given to the people. It was on Tuesday that the court directed me specifically to go through my entire records and to make sure that I have completely satisfied myself, that I have gone through and found out everything that has not been turned over. And we did an exhaustive process, Your Honor, and we followed through with the court's warnings and the court's directions. And that was how we were able to find out that there were 12 statements that had fallen through the crack. 12 statements out of hundreds of names that were given by the prosecution and hundreds of names that were provided by the defense. Now, Your Honor, of these 12 individuals whom statements have been prepared, there are 5 whom I reasonably expect that I will be offering testimony at trial. Therefore, Your Honor, when the court considers the propriety of a sanction, the court should do so within the context of reality. It doesn't make much justice or fairness to cry out numbers or to call out names without knowing in actuality the impact that it's going to have on this trial. And Your Honor, it cannot be ignored that this is January the 26th, the start of the beginning of the case. It is a day when typically, in preparation for the trial, the lawyers huddle together, the lawyers review the state of the record, the lawyers review the state of all of the pretrial arguments and rulings, and get together and decide whom we now reasonably expect to call. And we did that. And even on doing that, Your Honor, we omitted the names of Ron Fishman, we omitted the names of Christian Reichardt, and those names will be soon added. But the people have added names just this very week, and we are already beginning their case, should have been today, perhaps tomorrow, but they too are still adding names. Your Honor, when you look at the 5 individuals whom we reasonably believe that we are actually going to call, it is my opinion that only 2 of those names are names that are unknown to the prosecution. And Your Honor, they talk about how they've been sandbagged. Yet in 24 hours, they have attempted to assassinate the character of Marianne Gertjes, one of our witnesses, by suggesting allegations that are totally untrue. And Your Honor, Mr. Cochran will deal with that more when he comes up. But Your Honor, there is a tremendously effective wheel that is already in place called the Los Angeles Police Department. And there is another cog in that wheel called the Los Angeles District Attorney's Office. And although they may have been given short time to adequately investigate some of the names, they've done a pretty good job in 24 hours. And I dare say they'll be able to do a much better job in the 2 months' time it's going to take, at a minimum, before we begin calling any witnesses on the defense. Your Honor, if this were the first day of the defendant's case, and we were then intending to call Mary Ann Gertjes or Ron Fishman or Christian Reichardt, I would not be making the same arguments to this court, because I would recognize that there would really be a clear prejudice. But when we have 400 names on a witness list, and when we have a 6-month trial estimate, and when we have the expectation that there will be dozens or scores of witnesses called, I believe this court may fashion a more equitable solution to this problem, a more equitable response to our mistakes, recognizing that these lawyers whom you also know, whom you also have some admiration for and respect for, whom you also believe would not maliciously or in bad faith attempt to sandbag or do all of the things that have been alleged. I think certainly, Your Honor, you don't come into this position in a vacuum, and certainly I think you can understand, given the massive size of this case, given the complexity of issues, given all of the witnesses who will be called, that it is likely that things fall through the cracks. Now, Your Honor, the people stood up here in December and tried to tell you all of the reasons why they made certain mistakes. And the court said that the code required that they immediately disclose and that they hadn't done so immediately. And the court then issued a sanction which the court felt was appropriate. I think the court should do the same sort of balancing today, because in December the 14th, or whenever that hearing was, opening statements were due to begin the following month. We have at least 2 months now before we're even going to call any of the defendant's witnesses. Your Honor, Mary Ann Gertjes is a name, as I suggest, that the district attorney knew of. Her statement taken in July gives the name of Patty Fairbanks or Patty Fair something, clearly suggesting that she had had contact with someone in the district attorney's office. Michelle Abduran, who's another name on our list, with a statement turned over yesterday, is also a person with whom they are aware. They have interviewed other witnesses about Miss Abduran and about the allegations that Nicole Brown Simpson struck her prior to her leaving the Simpson home. Joel Pitkoff, who was an employee of Ford, is a witness who we intend to call, who is probably unknown to the prosecution. And on that one, I would accept the sanction of allowing them to adequately provide or perform background investigation and background research and try to challenge the strength of the numbers that he is going to offer and require us to wait and receive permission from this court before we mention his name or before we call Mr. Pitkoff as a witness in this case. Kevin Whalen, the courier, is another person who I respectfully believe was in fact unknown to the people. And similarly, it would be measured and proper for the court to impose that sort of a sanction. Mark Partridge is the fifth of the names that I gave witness statements for yesterday, whom we do intend to call. But, Your Honor, when I reviewed my list this morning, I saw that there was a one-page statement of Mr. Partridge that was turned over in August. What I turned over yesterday was 2 additional pages. So therefore, they cannot complain to this court that they did not know Mr. Partridge and that they were not aware of what evidence he would offer in this case. So it would not be proper or fair to include him with the other 4 names. Ron Fishman, Your Honor, is a friend of Mr. Simpson. When we go down to lockup or go down to county jail and have conversations with Mr. Simpson, and we take notes during those conversations, and we'll ask him about what would Ron Fishman say, and Ron Fishman may make certain comments, or Mr. Simpson may make certain comments about what he believes Ron Fishman will say, or Joe Stellini will say, or Louis Marks will say. Your Honor, when we're thinking about calling witnesses weeks or months in advance, we do not have time to spend on limited resources, and they are in fact limited, for investigator time, and there are 2 investigators now only working on Mr. Simpson's behalf on a full-time basis to try to track down friendly, favorable witnesses whom we will not call for at least the next 2 months or so. And therefore, because we do not want to be sanctioned by preclusion, we then put their names on the witness list. And sometimes, Your Honor, we put the names on the witness list before we even have a copy of the address or the telephone number, because we expect reasonably and fairly that they will be called as witnesses, and that by the time it is relevant and necessary, we'll be able to provide continuing discovery, because it is, in fact, a continuing process. Your Honor, there are occasions when we've interviewed or spoken with, Mr. Cochran would speak to, for example, Henry Lee, Barbara Wolf, Michael Baden. These are individuals who are on their witness list. They are aware of the names. And I do not believe that the people have cited a case that argues that when a lawyer speaks to an expert about something that the lawyer may say in his opening statement, or about a proper response to the suggestions in the people's opening, that by that conversation alone, he is required to reduce that conversation to a discoverable document and then immediately turn it over to the other side. That is not the obligations, even under Prop 115 or the U.S. Constitution or the California Constitution, Your Honor, because this man still has Fifth Amendment rights that still survive even Prop 115. Your Honor, they talk about not knowing about Dr. Kary Mullis, the Nobel Prize winner. I represent to the court that Dr. Mullis was a witness in the Wynn case, a case where Mr. Robert Blazier was the defense attorney in, a case with some of the same DNA issues, and a case where Mr. Blazier won and the court decided that DNA was not adequately reliable to be admitted in a criminal case. The district attorney's office is aware of that. And Your Honor, I believe that if Mr. Darden were to check with Mr. Woody Clark and Mr. Rock Harmon, he would learn that they have attempted to obtain Mr. Mullis's testimony in that particular case, that indeed Mr. Harmon sought to be introduced as a special district attorney in that case to help cross-examine some of the defendant's experts. So for them to say that, lo and behold, they didn't know, that they are surprised, I suggest to the court, is not totally with good faith.
Mr. Douglas, is Mr. Mullis on your witness list?
Your Honor, I've just looked for today, and he was on the list that we gave in October of complying back and forth with who our DNA experts are. He was not placed on our supplemental list, but he will. But that list, Your Honor, of DNA experts responded to their list of DNA experts. It was turned over to the district attorney. Mr. Clark, Mr. Harmon, and Ms. Khan are aware of each of them.
Was his CV exchanged in accordance with our agreement?
My understanding is, Your Honor, and Mr. Scheck is no longer here in court. Hopefully he's watching on a television with his family in New York City. But it's my understanding, Your Honor, that both sides have now mutually exchanged resumes of each of the DNA experts. But that's my understanding secondhand from Mr. Scheck. There's a suggestion, Your Honor, that Barbara Wolf was a surprise. Ms. Wolf's name, her address, her telephone number were provided in August of 1994. Again, we have conversations with Ms. Wolf. We do not reduce those conversations down in written form. There are no reports from Barbara Wolf concerning her testimony or her conclusions or her findings in this case. There are no reports from Dr. Michael Baden concerning his testimony, his conclusions, or findings in this case. There are no reports from Dr. Henry Lee, who is in fact the preeminent blood splatter expert in America concerning his conclusions, his findings, or his impressions in this case. We are aware if any such report is generated that it is discoverable, and we will do so. Your Honor, Mr. Weitzman is an attorney that Mr. Cochran has known for 30 years. I have enjoyed the pleasure of his company for 10, and I call him on the phone at home if I need to. When I say, Howie, tell me about what happened at the jail, and he says, they told me I had to leave, I do not think law or the code requires that I put that in a writing and turn it over to the other side. Skip Taft has been Mr. Simpson's personal business attorney for over 20 years. When he tells me that the police officers told him that they had to leave when Mr. Simpson was being interviewed, that is not a conversation that I would put down in writing. Whether or not the disclosure of the envelope was a proper function to present to the jury is not really a discovery issue, Your Honor. Is not really a discovery issue. That is properly a 402 issue. But remember, what happened was Mr. Hodgman stood up, Mr. Cochran walked over, told him what he's going to do, giving him the benefit of his information, allowing him to lodge an objection. It was lodged, sidebar was approached, the matter was resolved, and he moved on. There is some question about the statement of Dino Bucola, Your Honor. Mr. Bucola's name was given on Monday, and the court asked me, do you expect me to believe that there is no report? And I said yes, and there was no report. But on January 24th, in part because His Honor gave those words to me, I had my investigator interview Mr. Bucola. That interview took place on January 24th, and the document was faxed to our courtroom fax at 4:16 p.m. that day. When I received that document, Your Honor, rather than leaving the courtroom, I went upstairs myself to the 18th floor and handed that document to Sherry Lewis, making sure that I could do everything that I could in the face of the slings and arrows that were slung my way to show my good faith, to show that I'm trying to play fair, and to obviate any accusations that I heard this afternoon. The prejudice, Your Honor, that the people have suggested is just not true. Before 1992, Your Honor, there was no reciprocal discovery. Yet there were murder cases, there were robbery cases, there were shoplifting cases, there were drunk driving cases where the people would open up their entire file and the defendants would give absolutely nothing. So for these histrionics to go on and for there to be the suggestion that this is the most egregious wrong in the history of jurisprudence is laughable, clearly laughable. Only since 1992, when the people of this state, not the legislator, thought in their wisdom to impose on the defendants the requirements of Prop 51, have those requirements been in place, and defense lawyers in this state are continuing to wrestle with the implications of that law. We are continuing to weigh and to balance our obligations to a law that we feel is unjust and our primary obligations to our client who has an absolute right against self-incrimination. And Your Honor, if it means that we weigh in favor of self-incrimination and that those interests are more profound and those interests are the strongest, and as a result, we must be precluded from offering the testimony of those witnesses until the end of the defense case, so be it.
Douglas, as a former longtime federal public defender, this scheme of reciprocal discovery is not unknown to you, and it's well settled in the law given to us by the United States Supreme Court that these schemes are not unconstitutional.
Your Honor, I'm not arguing that the schemes are unconstitutional, but I argue that as a defense lawyer, I must constantly, daily wrestle with the internal conflict within me of resolving a law that I feel is unfair, a law that I feel is unjust, but a law that I'm compelled to follow. And there are conflicts, Your Honor, that are occurring across the defense offices in the state, in public defender offices everywhere. No one who represents a man accused of a crime, particularly a murder case, enjoys complying with that law. But we must, and we try to. Your Honor, I recognize that it is not a constitutional issue solely. I recognize the wisdom of the courts. I do not argue that I should not or must not comply with the rule, even though I feel it unjust. And I do comply, Your Honor. But I offer to the court that when the court measures and balances and weighs everything, when the court does equity, which is indeed one of the most important roles of a judge, that a court balance the equity of the prejudice to the defendants and the real prejudice, not just the puffed up souffle of prejudice that we've heard this afternoon, but the real prejudice against reasonable solutions to a clear and understandable mistake.
Mr. Cochran?
Thank you.
Good afternoon, counsel.
Good afternoon, Your Honor. Of all the lawyers who've addressed you, Your Honor, this afternoon, I'm going to try and be the shortest if I can. I'm sure you've been very patient as always and listened to us. I'm going to try not to raise my voice, Your Honor, because I think that it's important that we always try to conduct ourselves as professionals, even in the face of some rather untoward attacks. But I ask the court to remember that in the prosecution presentation, Mr. Darden, my good friend Mr. Darden, and I'm reminded that my wife is present in court here today, the court knows, and during the break I introduced her to Chris Darden, and Chris says, I'm your husband's good friend, and I told my wife, I certainly hope that you don't love me like he does. I think I might be in trouble. But I want to point out to the court that that with regard to Mr. Darden and some of these histrionics we've heard over the last couple of days, Mr. Darden is the same person who stood before you and told you that if we interrogated any police officer like Mark Furman with any racial slurs, it would so pollute. We could not pursue racial animus. It would so pollute this jury that they couldn't get a fair trial. Their whole case would fall apart. Remember that? You have to understand, put in perspective. They're the same people who brought you that, which is not going to be true, and I think everybody agrees with that. The counsel made a number of statements in their opening statement, and I think we should put things in perspective about opening statements, Your Honor. You have said on a number of occasions, and I said, we all said when we got up, opening statements are not evidence, but we expect to prove. What we expect to prove in good faith. If you don't prove that, then you suffer the slings and arrows that occurs with that. For them to stand here and talk about that they have suffered, there's an uneven playing field. Your Honor, for the first time in 7 months yesterday, somebody was able to get up and say something on behalf of Mr. Simpson. And that's all that took place. All I did was try to address what they had said, Your Honor. And with
Objection, this is not relevant to the matter before this court. And Mr. DeCosmo has already addressed the court.
Ms. Clark, please, when we're here outside of the presence of the jury, I'll hear the complete comment of counsel, please, without objection. You'll have an opportunity to respond to this. Mr. Cochran.
Thank you, Your Honor, again. With regard to this, I tried to address the things that they'd said in their opening statement, and I felt they said a number of outrageous things that they couldn't prove by any stretch of the imagination. But I didn't stand up. I didn't come crying to you that night and said, look, Judge, he can't prove those things. He can't prove those things of domestic discord he talked about. That's not going to be, because we don't try cases that way, Judge. I'll just wait until I get my chance to tell the jury what I think, and then I will deal with the evidence. It's the evidence that we'll be talking about on this case. Now, certainly, for anyone to stand here and say that after 32 years of practice, that I would in any way jeopardize my reputation or do something untoward in a case, I would never do that. I would never, ever do that. What we're talking about here, and I wouldn't stand up as Ms. Clark did and tell the jury that Alan Park says he saw a Bronco parked there. I didn't jump on that. I just came back and read what he said. I don't have to call anybody a liar. I think in this case, that's the problem with them. They always want to label everybody. I would much prefer reading the testimony. And then I think it makes it clear. That's what I think we'll be doing or trying to do. Now, they make a big thing about all the things that I said. And it turns out, Judge, with regard to the things I talked about yesterday, that Dan Mandel and Ellen Aronson, very well known to them. They had all the reports. They talked to him. We had talked to him. Tom Lang, they talked to him. We had talked to him. As Mr. Douglas points out, Rosa Lopez, they talked to him. We had talked to him. Mr. Douglas has explained the situation with Marianne Gertjes, and I apologize to the court for that. Certainly, I thought that had been turned over. The last thing in my mind to try to do that. But I want to tell the court something about the responsibilities of counsel and why we need to be professional. During the break, we received a call in this courtroom from Marianne Gertjes' lawyer. She was so distraught. She is totally distraught at having been called a thief on television by Mr. Darden. He should be real happy that he made these statements within this courtroom. Her lawyers are incensed. This woman is very, very, very upset. She says it's absolutely untrue, and what she said is the truth. I mean, it's ironic and outrageous that they would do that. It seems to me then that whenever they stand up to talk, Judge, it has to be character assassination, whether it's OJ Simpson, whether it's Marianne Gertjes, whether it's at the end of this morning where he stands up and says, everybody on our list is a liar, a thief, or a felon. Isn't that interesting, Judge, that anybody that they don't call, becomes some very bad person? I don't think you conduct yourself that way, and I don't think that's appropriate when you talk about how we appear and how the system appears around the country. Now, more specifically, I've indicated to the court about Marianne Gertjes, and the court, Mr. Douglas has talked about Carrie Mullis. There's no confusion there. There's no confusion with the people regarding Cora and Ron Fishman. They know all these people because they all ran around together, Your Honor. And if it was inadvertent we left their name off, we apologize for that. I assume those names have been taken care of. My job has not been that aspect of it. I'm not trying to shy away from it, but everybody has responsibilities and roles, and so you can't do everything. But we want to adhere to that. Certainly, it's outrageous for anyone to say that we think we're above anything. I've practiced law in the counties, in the courts of this county for 32 or 33 years. I am the blue-collar lawyer that he's talking about, except you see, I was on that side for almost half the time, and I've been out here earning a living the rest of the time. And so I understand both sides. I understand. Now, one of these days, when they get up enough nerve and come on this side, they'll understand, Judge, that it's tough when you have to run your own practice. And Marcia was there for a short time. Yes, she was, to the credit, but not as long as we've been here. And she'd understand what Mr. Douglas was trying to say, and I want to clarify this as being a little older, maybe a little calmer at this point, that there is this philosophical thing. And I want to point it out to you, Your Honor. And the other day we had this conversation, we talked about defense lawyers and their role, and you said you've been a defense lawyer. When I go to the jail and I talk to my client, and he tells me something, I don't have any obligation to tell them that, Judge. If I know that he has rheumatoid arthritis, if I know that he had trouble shuffling cards on June 12th, there's no report on that, Judge. If, as Mr. Douglas says, if I talked to Howard Weitzman, whom I've known for 30 years, we represent Michael Jackson together. If I talk to him and I know what he and Skip Taft will say, there's no report on that. I don't think that you require us, in the midst of everything else, to sit down and write a report regarding that. Now, they know Howard Weitzman was down there. They know Skip Taft was there. This is no surprise, Judge. What happened, Judge, yesterday, and I want you to put this in perspective, was finally somebody from the defense had an opportunity to stand up and tell the facts as we understood them. If they don't like those facts, they say they feel is unfair. Judge, if we don't prove those facts, then they're all the better for it. They benefit from that. Nobody's trying to sandbag them. For months, they talked and tried this man in the press. They talk about unclean hands, to vilify somebody like this man. And then even to stand here today, Your Honor, and refer to him as a dream defendant. Your Honor, who would ever want to be a defendant? That's if ever there was an oxymoron, Your Honor, that may be it, isn't it? A dream defendant? I mean, who wants to be a defendant? But that's to malign all of us. And we don't take it personally because Mr. Darden says he loves me. So since he loves me, and I do. I'm not going to take it personally. But Judge, go on and look at the rest of the list. Joe Stellini is a friend of the defendants. There's no report. We've not interviewed Joe Stellini. We don't have unlimited resources like they have, Your Honor. Michael Baden and Barbara Wolf came out here the week of these murders, if the court pleases. They went over, and there's a letter where Mr. Shapiro offered to help the LAPD and the coroner's office help solve this crime, which was rejected. They went over to the lab. They went over, looked at these exhibits. They know about them from the beginning, Judge. They were there like June 15th. They know about it. The one report from Henry Lee that you know about, we turned that over. I mean, we don't have any other reports. Now, I mean, I can't make, these are busy men. Henry Lee is the foremost blood splatter crime scene forensic expert in the country. And so they might not like we have Henry Lee on the side, but that's not the reason to bar us. They know about it. Same thing with Carrie Mullis. If he wins the Nobel Peace Prize and they don't have him, they may not like that, but that doesn't level the playing field, Judge. They know about it.
I don't think he won the Peace Prize.
I said that. You know, Judge, I said that. I'm going to make that clear. The Nobel Prize for Chemistry. I had Dr. King on the mind yesterday when I was saying that, who did win the Nobel Peace Prize.
Linus Pauling won both. Never mind.
Yes,
Never.
the only one. No, you
Never.
would know those facts, too. I'm not surprised, Judge. You would. And Judge, is he on our witness list yet? Okay. Well, if we put him on our list, then I'll let you know. If we put him on your list, Judge, I'll let you know.
If he appears, I'll be amazed.
Then you'll be amazed. Well, I think so, Judge. Your Honor, to continue on in a serious vein, so with regard to Michael Baden, Henry Lee, and Barbara Wolf, they're all out here the first week, Judge. What are they talking about? And there are no reports. I'm telling you, there are no reports. These are our experts. I don't have any reports. When we get reports, I will make sure, and Mr. Douglas will make sure that you get those reports. How about the envelope? I walked over to Your Honor's clerk, and I said, may I get this envelope earlier? And then I asked Mr. Douglas to get it. Before I finished doing anything, it was over here. I walked over to Mr. Hodgman, and I said, let me make an offer of proof to you. I'm not going to try to open this. What I was seeking to try to do, and you'll have to make the judgment on this. I'm a trial lawyer. And this is a court's exhibit, so it's not anything I had. And I was concerned about the chain of custody. And I made the offer of proof there. What I was seeking to try and do was use this as another example of the people's rush to judgment. Now, I know they wouldn't like me to use those words, Judge, but they can't stop me from using those words. And that was another example, as I tried to demonstrate with the fingernails and with the other things that they didn't bother checking up on. When Mr. Hodgman said, well, I like to approach the bench. We approached the bench. You, at first, as you recall, I'll tell you what you did, at first felt that it was appropriate. When you inquired further as to whether they had some report, which apparently Mr. Hodgman said they didn't have, which I didn't have either, and I thought they probably had it. You said, well, if they don't have that report, Mr. Cochran, you can't do it. Well, we put it back. Never talked about it. Now, that gets blown all out of proportions, and we still don't know until his speculation. He doesn't know what's in that envelope. Let me make that clear. I don't think he knows. If he does, that's something else that they know we don't, that they claim they don't know. But we've never said what's in that envelope. Never, and we didn't yesterday at all. The jurors don't know anything about that. So, with regard to this man's physical condition, respect for him, as I've indicated. And I'm very concerned about his physical condition, and I hope that he'll get well soon. And I'm very concerned about it. I've discussed that with our client. But talk about sanctions. When have you ever seen a case, Judge, where, first of all, they get up and make an unfettered opening statement to our jury because we wanted to be professional? We didn't object to the very end. It became absolutely necessary. Because of events beyond our control, I couldn't start that day. We had to leave. Jurors got to go home that night. We came back the next day, and I got my chance to make the opening statement, in which the things that I said, I expect to prove. Things that I know from my client, I don't think that they can change that or talk about leveling the playing field. Because apparently they felt the job that I did made them nervous and upset the next day. We saw these histrionics. And so they now want you to carve out some new law. They have no cases that cite this, and you have a lot of discretion, Judge. They want to carve out some new thing to give them like another opening so they can get back up and talk. Well, then do I get a chance to respond to that? I mean, that doesn't make any sense. Everything that we did, we've done in good faith. We want to try this case as much as they did. In fact, you recall I've said for the last 10 days, let's stop all this posturing. Let's get this case on the way. The final thing I want to say is this, that it's rarely productive of good to malign citizens. You know, I'm a big fighter for jurors and for witnesses. And for Mr. Darden to stand here and say that Christian Reinhardt, was dumped by Faye Resnick is perhaps the greatest bit of hyperbole I've ever heard. That is so far from the truth. It strains credulity. It didn't happen. He put her out because she was using drugs. And after she used drugs so badly, in that 5 or 6 day period, he was the one who helped put her in a drug treatment place, Judge.
Cochran, as interesting as that conversation about that probably is and probably will be later.
Sure.
My interest is in the people's request for sanctions. They've asked me to tell the jury that I'm striking from your comments and for them to ignore your references to these various witnesses and items that they've discussed. They've asked me to admonish them that the mention of those was not appropriate because the prosecution was entitled to know of those witness statements or the identity of those witnesses before the opening statement was made. And they're asking for a 30-day continuance. So I'd like your observations on the various sanctions that the prosecution has requested.
Let me do that. Thank you, Your Honor. And the only reason I was thinking about the right card, I just felt you have to set the record straight sometime. There's a man, he's a doctor, Judge. He's out there having these slings and arrows. We can take it, but it's not fair to these other people to go through Christopher Darden's thing. I know he loves them too, but we can take it better. Judge, with regard to the 30 days, I think, again, Your Honor, it's almost like they're kidding about 30 days. Your Honor, they haven't even called their first witness. You know, you're very optimistic, and so am I generally. I'd like to think the defense is going to start within 2 months, probably more like 3 months. Judge, by that time, they'll have time to investigate everything. They've got the LAPD, they've got the DA's office, they've got everything. They got all this information they supposedly got on Marianne Gersh's, supposedly, which apparently isn't true, but they can have all the time they want to investigate. And as Mr. Douglas says, we're not trying to play any games, and to show that, they can have as much time as they want. I don't mind if we're going to call her as a witness, calling her at whatever time you set. I mean, we would play by the rules. I don't have any problem. We made a mistake with regard to her. With regard to the other witnesses, Judge, I don't think they can show there were any mistakes. I think that they knew about Carrie Mullis. They knew, I mean, they say to me that I say that he has this man suffers from rheumatoid arthritis. Those are the facts, and I'll be able to prove that. What do we strike based upon that? They don't like the truth, and they want to try to change it around. To talking about a level playing field. So as I listened to it, I didn't see, and I try to go through the list of witnesses. I mentioned Ron Fishman, and they know about Ron Fishman. We hadn't turned that report over. With Chris Reichart, they know about Chris Reichart, Judge, because they've interviewed him. We don't have a report, I don't think, from Christian Reichart. We don't have a report. And we don't have a report from Fishman, so we have nothing to turn over. They know about Lenore Walker, Judge. In fact, let me respond to that on Lenore Walker. With regard to Lenore Walker, we got a special order. She went to the jail over 2 weekends. She has not finished her examination, as I indicated to the jurors. We don't have a report from her, and we don't have one for either from Geraldine Butch Staley either, who's their associate, because they were due to go to the jail last weekend to finish the reports. They haven't finished them, or they finished the testing. So again, that's not anything. We tried to give them the CV. We've done what we could on that. With regard to Michelle Abduran, they know about Michelle Abduran. Joe Stellini, there's no report. So, Judge, the sanctions they're asking are far out of line with what should take place. I think we're in a similar position than what they were. What I'm trying to indicate to you is that we've not done anything intentionally. We would not do that. We're just trying to get what we know we can prove before this jury at the earliest possible time. It's the first time we had to do that. And so I would ask the court not to try to come back and then gut my opening statement by trying to pick out things that we said if it's the same situation. If we don't prove those things, the problem comes with that. Where does it say that because in an opening statement, I make a statement believing that they have Marianne Gerges' testimony and they don't have it, when they should have, because of the statement of itself. In that statement, if you look at it, has the DA's phone number. Marianne Gerges says she has the DA's phone number from Patty Fairbanks, who puts her on hold, and she tells about calling all these police departments. So and this is an investigator I have never met with, and I received that report within the last couple of days before the argument. So I think that if you look at it, what I think you should do is put us in the same position that you put the prosecution in when they were faced with the same situation in December. I mean, what's fair for them is fair for us. We wouldn't ask any more or any less. It doesn't go to my opening statement. Just much of what you have seen over the last couple of days, make no mistake about it, is to try to keep me from getting back up before that jury. There is an ultimate sanction today. Now, I believe that Bill Hodgman is sick, but everything that's happened, when Mr. Darden kept talking and saying the same thing 6 or 7 times, I thought he was filibustering, and obviously it was so I couldn't talk to this jury today. But ultimately, Judge, no matter what they do, I get to finish talking to this jury. That's not a sanction they can impose. I get to get back up there. They're not going to like that. And so that's what this is about. And so I'd ask you to be fair in that, and be fair like I thought you were imposing to them. If we slipped up, I'm telling you it was not intentional. We would not do that. And if we slipped up, the same sanctions they got in December should pertain to us. And if that happens, it has nothing to do with the opening statement. I haven't misled anybody. If Christian Reichart,
Well, the problem is I can't really impose the same sanction at this point because part of the sanction was I told them they could not use certain witnesses in their case in chief until they had completed their original witness list, and they could not mention it in opening statement, which as far as Mr. Darden is concerned, I essentially took the heart out of his domestic violence argument because he was not able to mention 3 or 4 other incidents that fill in certain time gaps. I assume that's the argument he's about to jump up and make.
When you say take the heart out of it,
Well, that's his argument.
okay, well, yes,
I'm asking you to respond
yes,
to that.
well, I will. I think that, Your Honor, with regard
So
to
I
that.
can't give you, or I can't impose upon you the same sanction.
Well, you can give, I think the thrust of it, though, Judge, isn't it that they would have an opportunity to try and check these things out? I mean, I think, for instance, Christian Reichert, they already know about him. We don't have a report. So that's maybe a bad example. They know about him. They already have a report, and maybe that's a bad example. I mean, the only one that I can really fix on, because they know about Ron Fishman, is Marianne Gertjes. And I'm just saying to Your Honor that in 24 hours, they've done all this work supposedly on the rest of the people, Judge, they knew about, and we don't have any reports on them. So I don't know where we go from there to saying, admonishing this jury regarding this. You admonished them, even after I didn't get a chance to talk to them for an whole evening. When they came in yesterday, you start off by saying, what counsel says is not evidence. And that's exactly what it is. It's not evidence. So, you know, we're going to have evidence. The case will ultimately be, why are they so afraid? The case will ultimately be decided. We want to uphold all the rules like everyone else. But why are they so worried about that, Judge? Ultimately, it's going to be the evidence that this case is decided upon. And that's all that I wanted us to get back to. The rest of these witnesses, and some of them, is that they knew about them. We don't have any reports, with the exception of Marianne Gertjes, that I can see as I look at the list. And I think that the sanctions are way out of line with where we are. And having understood what your sanctions were back then, we have to deal with where we are at this point. With regard to Marianne Gertjes, this is a witness who gave a statement. I don't know her. Have a statement from her. The investigators talked to her. And that's how it came to me. I assume they had it, and I wasn't aware they did. And again, I apologize for that. But I don't think that's any reason that Mr. Simpson should have to suffer, where these jurors would have to be told, oh, gee, it's not evidence, but just disregard that. It's not evidence. And, you know, and Judge, if we do it based upon that, I could come back tomorrow and say to you, Judge, I want to look at the transcript for all the times Ms. Clark was argumentative that I didn't object because as an officer of this court and a gentleman, I didn't want to do that. That's like running back, doing something like that. I don't want to do that. I want to get this trial on. I want to finish my opening statement so they can call their first witnesses. And so what I'm going to ask you to do is to fashion something that's reasonable. You're wise, and in these situations, it calls for a wise decision, where we have done something in good faith. And then I will conclude by saying this, Judge. We certainly don't refer to ourselves as a dream team. Just a collection of lawyers who try and do the best we can for our client. And that's all we're doing. And others can refer, Mr. Darden can refer to us derisively or any way he wants to. But we're just trying to do our job. And in that, Judge, we're trying to represent our client to the best of our ability. I think you know, we would never intentionally mislead this court. We would not do that. I would not do that. I know that my reputation means far too much to me. And this case is not the last case of my career. And so we don't have the obsession that some seem to have about this case. We want to try this case. And we think we're going to win this case. But we're not out here trying to win this case at all costs. We're trying to do it methodically and do the job that we're paid to do. And that's what we expect to do, ethically and morally, Your Honor. And all I ask you to do is to allow us, remember that part of the sanctions have already been the delays, the internal delays in my opening statement getting back to that jury. Allow me to get back to that jury without any real unnecessary delay. If the court felt that there was some problem with regard to Bill Hodgman, obviously we want to listen to that. I mean, that's something that I am sensitive to, and I've talked to Mr. Simpson about that, although he wants to proceed as fast as he can. I'm sensitive to that. But with regard to these other things, Judge, when you look at when it's reduced down, you know, things that I knew because my client told me, I don't have an obligation to that. And I hope I put the envelope and the other things in perspective. So I'd answer any other questions that Your Honor has for me at this point.
Well, you're objecting to the 30-day continuance that Mr. Darden has suggested.
Yes, Your Honor, I think that is far, far too long. What are you going to do for 30 days? We have a jury that's being sequestered. They've wasted another whole day today. I don't have to tell you that, but those are the facts.
All right. Thank you, counsel. All right, Ms. Clark, briefly, please. And let me ask you a couple of questions before we launch into this. You concede that Dr. Mullis was on the DNA list for the defense for the DNA?
Yes, I do. He was on the Kelly Fry list.
Yep.
His deletion in the trial list led us to believe that he was not going to be called at trial. And that is the problem that is posed, is that we were just beginning to prepare for the Kelly Fry, and then matters were transpiring at a rapid pace. We ceased preparation when it appeared that there was not going to be a Kelly Fry hearing. And that is the problem with him, but it's not nearly as egregious as the others, because we did have some notice of his existence for the defense. Let me indicate to the court that with respect to the 30 days, I believe it was the defense who indicated, and at the court's request prior to this, when they wanted time to investigate witnesses that they claimed they were given late notice of, although they got them far in advance of the last hour of opening statement, they asked for 6 weeks. They thought that was a reasonable time for investigation, as did the court. We're asking for less, even though we would be, under a parity of reasoning, entitled to the same amount of time for reasonable investigation. We are not obsessed with this case, Your Honor, but I wonder about the defense obsession, because their desperate tactics in throwing ethics out the window and behaving as they have is evidence of clearly the opposite of wanting the fairness and justice that we're entitled to in this case. There should be no mistake about it. This conduct should not be minimized this way. Mr. Cochran's very persuasive, very talented, very charismatic, but I'm sorry, Your Honor, in this case, he is wrong. He has done wrong. This is not the way to behave. This is not ethical conduct or behavior. And as I told the court, he glibly stands up to say, well, the people can address it all in closing argument. No. See, it's too late. Because by then, Your Honor, there have been months of time for whatever that jury has picked up that will never be addressed in trial, those witnesses that Mr. Cochran referred to that may never be called out of some kind of fear that he's thinking of, or witnesses that never appear at all, that after they've been represented in front of this jury, they will have that witness in the back of their mind, and that may be enough to persuade the one. Any kind of relief that the court grants us at this point may still not be enough, because the damage may be indelible at this point, after him having mentioned all these people that he himself knows is in danger of not ultimately being called, because once they're investigated, it's determined they have records, they have felony records. These are people that really will not withstand the scrutiny. They know it. The defense knows it. And the willfulness of their tactics in delaying the discovery is shown by virtue of one simple fact. Early on in these proceedings, the defense floated up the name of Frank Chuchulo from Happy Camp. This was a man who came forward to say that he saw burglars, 2 white burglars, leaving the home of Nicole Brown. It was then discovered that he'd come forward to offer false information on other famous cases, and his credibility was exploded, as it deserved to be. And the defense realized that then they're going to have to hide their witnesses to prevent the exposure that would show them to be as incredible as they are. And that's what they've done in this case. So it's a very willful thing, and it's not a minor thing. This is a major form of misconduct that has occurred, and I don't want Mr. Cochran to minimize it this way. It is major. And if we look at, let me just contrast it for a moment, because I know what the court is going to say. Okay? Their statements were taken 4 or 5. I saw it.
How am I going to rule?
No. What? I'm sorry.
Never mind.
The counsel wants to compare the gravity of their misconduct to what occurred with the people, and let me contrast the two. The statements turned over by the people were 2 and 3 weeks late. The statements turned over by the defense were 4, 5, and even 7 months late. We were sanctioned for that for just 2 or 3 weeks, and now they're fighting the sanction for 4, 5, and even 7 months for material witnesses. Obviously, witnesses they think are very important, because Mr. Cochran is outlining their testimony to the jury. And when you also look at it in this context, Your Honor, out of the tens of thousands of pages that we've turned over, dozens of videotapes, dozens of audio tapes, we were slow to turn over by that I mean 2 to 3 weeks, a few pages of discovery, compared to what they did We had 70 pages of discovery, Your Honor, until the last 2 or 3 days. Now they have doubled the amount of discovery in the last 2 or 3 days. What that shows this court is not only that the gravity is very severe, that the misconduct is very serious, but that it is not inadvertent and cannot be claimed to be. You don't overlook over half your case. And that's what they claim to be doing. I don't believe it. I don't believe it. Mr. Cochran is an excellent lawyer. He knows what he intends to use. He knew what he intended to tell this jury. His statement was typed and it was prepared. And he cannot come before this court and tell us that he didn't know about these witnesses before or was unaware of their statements. And the fact that Mr. Jones can Mr. Douglas can stand up before this court and say and try to excuse the misconduct by saying, well, this wasn't always the law. It makes it even more egregious because what he's indicating is a desire to thwart the law. A desire based on his own belief about what he should be able to do as defense counsel. Unfortunately, the voters of this state have spoken. They have said, we will not countenance any more of this hide-the-ball stuff, this shell game in the course of a criminal trial. We want it to be a real search for the truth. We want both sides to air their witnesses so that everybody can have full and complete investigation. And that is the problem with what defense counsel has done. They are trying to prevent us from doing our job. I want Mr. Cochran to get up and speak to this jury as long as he wants to. I don't want to stop him from talking. I want this opening statement to get going and to get completed. I want him to be able to put on every witness he desires. All I ask is the ability for the people to investigate these witnesses so that the jury gets the whole truth, so that we have an opportunity to show the jury who these people really are. And when these people are hidden from our investigators, we cannot let the jury does not get the true picture of who they really are. I would not be doing my job if defense counsel were permitted to trot a parade of witnesses up to that witness stand and I were to sit back and say, what's your name? What time is it today? Thank you very much. I should be fired for that. It's our job to search for the truth, and it's our job to show this jury the real credibility of who these people are, what these witnesses really is. And if this jury doesn't get to see that, they're deprived of the truth. And if they're deprived of the truth, the people of this state are deprived of justice, and I cannot allow that. That is not my job. My job as a representative of the people is to see that that does not happen, that any witness who is called is given thorough and complete examination. And what they are attempting to do here is prevent that. Mary Ann Gerches now claims that she called our office. This is not a woman whose credibility is unsullied. And if she did call the office, which counsel knows because counsel had the same problem, we've all gotten thousands of calls from every Tom, Dick, and Harry that wants to get involved in this case. If the person doesn't pursue it, sometimes they don't get reached again. But I think it's very interesting that they say that. What, are we supposed to now say that the lawyers can rely on the witnesses to give discovery? Is that what he's saying? She's supposed to give her discovery to us? I mean, somehow he's putting the obligation on her to come forward. No. The obligation is not on the witnesses to turn their statements in. The obligation is not on the DA's office to go begging for the defense witnesses to come and talk to us. The obligation is for the defense to give us what they've got, the same as it is for us to give them what we've got, and we have done so diligently at every bend and turn. We have not attempted to avoid it in any way. Now, I think that what the court should know is that Mr. Douglas's position vis-a-vis the law, vis-a-vis his requirements in terms of turning over discovery, taking reports, and reducing statements to writing is wrong. 100% wrong. It's so wrong that previous courts have found that conduct to be contemptuous. I cite the court to the case of In Re Serra, S-E-R-R-A, 484 Fed 2nd 947. The court held that a defense attorney should be held in contempt for asking an expert to refrain from writing a report in order to avoid discovery. Also cite the court to Standeffer versus Superior Court, 18 Cal. 4th 672. It cautioned again the attorney not to direct an expert to avoid writing a report in order to avoid discovery. Counsel has deliberately done an end run around the discovery laws, basically by trying to get their discovery from the mouth of their client. Here, Mr. Simpson, go call Ron Fishman, tell us what he'll say. And then they go and ask Mr. Simpson. I mean, that's a very clever game, but it certainly does not serve the ends of justice, and it does not comport with the spirit and the letter of the law under 1054. We love the fact that they have Henry Lee for an expert. But if he's such a great expert, he's so well renowned, and I understand he is, how could he not have written a report with respect to all of the work that counsel has told us he's performed in this case and will testify to here? No report? He's been on the case since day one. We're all aware of that. And to tell us now that he has no report to offer us, that Dr. Bowden has no report to offer us, that Sylvia Wolf has no report to offer us, this is unbelievable. this conduct cannot be minimized, should not be minimized. We have been placed in it's a very unfair position that we are placed in. I think that the goal of a trial is for the truth to emerge, and it's not for a lawyer to hold in his head information that he or she may use to ambush the case with. And that's what we have here. It's a trial by ambush. That's the strategy. The people would request, number one, that the court admonish the jury with respect to counsel's misconduct, as I've indicated earlier. Number two, if the court is not inclined to strike the comments, the offensive comments by Mr. Cochran, and let me indicate about that envelope, he waved it in front of that jury and every single one of them saw it. And we all know that after the preliminary hearing with what occurred there, everybody knows about the envelope. Everyone on the jury said so. Mr. Cochran knew what he was doing. That jury saw what he was doing, and that was a setup, as sure as I'm standing here, because he knew that he was going to surprise us with that, a surprise tactic, that we would object, and that the jury would then see the objection and maybe conclude that we were trying to hide evidence. When in fact what has happened is we've been hidden from. We don't know what's in the envelope. We haven't seen the reports. Counsel knows better than we do. They know what they're waving around. We don't even know. All we're asking is let us know. We want to know. We want to know what their witnesses have to say. We want to know what the evidence is. Is that asking so much? Under 1054, it's not asking anything that we're not entitled to. That's all we ask for. And under 1054, there are a certain number of sanctions that are allowed under the law, and Mr. Cochran is aware of that. And if the court is not inclined to strike the offensive comments, then the people would request that we be allowed to reopen to address those matters, but that's in conjunction with the admonition, and that after the conclusion of opening statement, that we be permitted a continuance in order to investigate all of these witnesses that were just recently thrown at us at the conclusion of Mr. Cochran's opening statement remarks yesterday. I think it's only the alternatives that I have posed to the court, I think, are the only way that the people can be made whole. We are not being hysterical here. We are simply asking for an opportunity to do our job. That's all we're asking.
How would I justify granting you a 30-day continuance if we all agree the people's case in chief is probably going to take between 2 and 3 months to present? Doesn't that give you adequate time to go out and prepare to rebut or to impeach these witnesses, these 12 or 14 witnesses who've just been disclosed?
While we're tied up in trial, we can't get involved in the investigation. That's the same game that's been played throughout this case. We're tied up in court with days and days of jury selection. We have to be out there too. We can't just send people out to do things for us without guiding. Yes. I don't think that the people's case is going to take 2 or 3 months. Not even close.
Promise?
Yeah, I mean, I'd like to, but I really don't think it's going to take that long, Your Honor, seriously. I think that the people's case might well be wrapped up in 4 to 6 weeks.
All right, do you have any other comment?
If the court would like, I think I have other case authority concerning the ability of the court to grant us the reopening of the statement.
Well, that's kind of an esoteric question. I think there are two other cases that I've been able to find in Lexis, but in other states.
I have a California case.
All right. Let me ask you another question. That's really an esoteric issue about reopening. What kind of
This case is right on point.
well, as after an abuse of discovery, it's right on point. Reopening.
It's not to address abuse of discovery, it's to address something else, but it does indicate that it would have been reversible error to deny the ability to reopen the opening statement.
Ooh. The thing a trial court never wants to hear about. All right, Ms. Clark, let me ask you this though: what kind of admonition would be appropriate here?
I think I indicated earlier what
No, I'm
my
talking
request was.
specifics. Words.
Didn't I? Oh.
Just to pick out each one of these individuals' things and tell them disregard these comments? To say during the course of the opening statement by the defense counsel, this witness was listed, this person was mentioned, this person, disregard all that? Is that what you're asking me to do?
There would have to be,
And then say the reason for this is because we have rules of discovery, that is disclosure of witnesses, because they were disclosed in the surprise of the prosecution, they don't get to talk about it in their opening statement. And that's the reason for the delay. Is that what you're asking me to do?
I would like, may I have a moment, Your Honor? We have to,
Well, I mean,
We
you're
haven't
asking
had
me,
a-
you're asking me to do things.
Right.
I want to know specifics. What are you asking me to do?
if the court would like me to actually frame the language of the admonition, I would be happy to do that. If the court could give us, well, it's kind of late already.
All right, well, before you answer that question, let me ask you the question that's more pressing on my mind is what is the condition of Mr. Hodgman this afternoon?
We don't have final word, and we will not have final word as to when he's going to be available to come back. We won't have that today.
Do we have any idea when he's going to be released? I saw Colleen Williams reporting a press conference down at the hospital.
Yeah, I believe the doctors held a press conference, but I have no idea. What the people would request is that the jury be admonished as follows: that defense counsel has committed serious acts of misconduct, that they are to view very carefully the opening statements, they are not evidence, and that to the extent that they fail to fulfill the promises made in an opening statement, any statements made should be disregarded because they do not constitute evidence.
Then
They should be-
that invites them to speculate that the whole thing is bad.
That what whole thing?
Don't I have to be more specific than that? Because certainly not all of Mr. Cochran's opening statement is in dispute, or the propriety of it.
Well, Your Honor, we're going to have to take a break so I can frame then something more specific. I can't at this time, but they do need to be admonished concerning counsel's misconduct. They need to be admonished to disregard counsel's statement concerning the witnesses who will not appear out of fear. That was a totally inappropriate comment, very improper, and the jury very prejudicial. The jurors should be admonished to totally disregard that. There's no evidence to that effect. And then we should ask counsel at this time.
Mr. Cochran, I'm aware of your 1335 request, so.
Yes.
We're
That's not-
entitled. We can litigate that later.
As soon as I receive a motion and application.
We also would request that the defense sit down with Mr. Cochran and review the balance of his opening statement to determine if there are any more witnesses he intends to mention that they've somehow magically forgotten to give us discovery of. We would also request that the court order them to reduce to writing all of these reports they carry around in their head with respect to the witnesses that are civilian as well as the experts who they intend to call. And we have no problem with the resumption of opening statement, provided it begins with the court's admonition to them
You want Mr. Hodgman to be here?
I would definitely prefer that Mr. Hodgman be here, Your Honor. And I'm going to have to find out how long it's going to be. I don't know.
All right.
I feel like it's unfair of me to make a request to wait for his return if I don't know what that is. And so I'm going to have to ask leave of the court to get further information before I make any request along those lines, either way. I mean, if he doesn't come back for 2 weeks, is that fair? That's not fair to defense. And so I should really find out how long we're talking about before I ask for anything.
Mr. Cochran, you have a plaintive look on your face.
It's not like a plaintiff will, but it seems like the press is being, like the plaintiff will. The press is being told about Mr. Hodgman's condition through press conferences and things, and why don't they take a break and then they can call and find out?
Because the press isn't being told when he's going to be released.
But I think they should make an effort to try to find out.
Well, we will.
All right, well, why don't you take 5 minutes? My court reporter tells me she's out of paper, so let's take 5 minutes. Why don't you make a phone call upstairs? And this is not a recess, so everybody stay in place.
I have asked to be beeped as soon as they find out. So
We don't turn on beepers in the courtroom, do we?
But my beeper isn't with me, so that's okay. My beeper's upstairs. They're going to call me. So I'm supposed to get a call the minute they find out.
All right, Ms. Robertson, what information did you receive from the ever-present Ms. Fairbanks? Mrs. Robertson, you'll need to speak up.
You indicated that it was trophy and doctors anticipated he would be released sometime next week, that it made his wife was requesting that he have a condition for time.
So he's going to remain in the hospital till next week?
That's what we
See, I had asked that as soon as we had knowledge that we'd be called, and they did. Thank you, guys. So that's all we know right now is that he'll be back sometime next week, at least released, but we don't know when he'll come back yet. That might be.
All right, in light of that,
Uh-huh.
Madam Reporter, can you change your paper? All right. Ms. Clark.
First of all, Ms. Fairbanks asked me to inform you that the ever-present Ms. Fairbanks is here. She's gotten word from the press conference that they will not state exactly when Mr. Hodgman is going to be released. The doctors would not give a definite date. And as for his return, it's uncertain as to whether it will be the beginning part of next week or the end of next week.
All right, in light of Mr. Hodgman's absence, when will you be prepared to go forward in his absence? Can you be prepared tomorrow to go forward?
With opening statements or with evidence? Opening
The
statements.
whole enchilada. I assume Mr. Cochran he indicated he had one other segment of the case that he wanted to talk about. And I assume, although that'll be a rather large part, I assume it's not the whole day. So I would assume that he would conclude his opening statement in the morning and that we would proceed to witnesses in the afternoon, assuming we started at a normal hour.
Well, I understood.
I mean, the court has not indicated any ruling so far on the people's request for a continuance to deal with the discovery that was just dumped on us over the past couple of days.
I'm asking you, when will you be able to do that? I'm mindful of Mr. Hodgman's absence. I'm mindful of the fact that he is a critical member of the prosecution team. I frankly will need time to go through my notes, prepare the record, because we were talking about, as I indicated, my recollection is we talked about 26 specific items of discovery and/or witnesses, so this is not something I feel comfortable ruling from the bench upon. So I probably will not be prepared to rule upon your request and the for sanctions until probably late tomorrow is my problem. And I don't know that I want to drag the jury down to sit around and wait all day again. I don't know the answer to your question.
What we could do is let, there's a possibility that Mr. Hodgman will return on Monday. If, for the purpose of having him present for opening statement, we could do that on Monday. But then, what I thought we could do is sever the issues of the opening statement being completed and then
Well-
the request for continuance.
You've dumped a rather large number of things in my lap. It also is going to require me to go back through and read Mr. Cochran's opening statement again to go through the record to see what's mentioned and where. So this is not something I'm going to be able to accomplish between now and 5 o'clock.
No. And, Your Honor, this is from the defense, this is not from the people. But,
Your request, though.
well, it is our request,
All right.
necessitated by. Anyway, why not start it, if we could have it go over to Monday for the purpose of completing opening statements. And at the conclusion of opening statements, would that give the court time to rule on the people's requests? And that way we would know where we stand.
All right. Let me just ask Mr. Cochran one question. All right, I'm contemplating going over to Monday. That'll give me time to review this, make my ruling, and we can find out definitively when Mr. Hodgman will be back. My inclination, though, is to direct the people to be ready to proceed if I rule that certain sanctions are appropriate, but that we're going to conclude the opening statements, that you be ready to proceed immediately, Mr. Cochran. And assuming that we proceed on Monday, that the prosecution also be ready to call witnesses Monday afternoon.
I'll be ready. I'm ready now, Your Honor.
I understand that. I'm ready too.
That'll be fine. I'm ready, and make no mistake, it's the people's motion, not ours, and we don't agree with it. The one thing I'd like to say, Your Honor, however, with
Well, the
regard-
situation is, the creation of the situation, though, I think rests on this side of the table, as Mr. Douglas conceded that these statements should have been disclosed, so.
I'm not trying, we just said that it was inadvertent. The point is, Your Honor.
No, and I compliment Mr. Douglas for being upfront, saying we should have done this.
That's the kind of lawyer that he is, Your Honor, and we'd like to see that on
But
the
it's
other
the
side.
creation of the problem.
That's, Your Honor, what I'd like to say is this, though. I would like to suggest to the court that I'd rather not have Marcia Clark drafting. I'd like for you to
No,
have that. I'd like
counsel.
to have that additional time. I'd rather not have her drafting anything that relates to us.
What I'm going to suggest is both sides submit by 10 o'clock tomorrow morning any admonition to the jury they feel is appropriate.
Thank you. I think that's fair.
All right.
Thank you.
All right,
That's
we'll
fair.
stand in
We'll be
recess.
ready on Monday?
9 a.m. Monday. Be prepared to go. Thank you, Counsel. 10 a.m.
Okay.